The cold is finally gone. Well, I've been waiting for someone like you to come along. I was going down a road so dark and full of demons, I lost my ground. My heart was stuck in hibernating, stuck in the ice where there's no feeling.
A very warm welcome to you. Today, we shall deal with Section 4 and Section 5 of the Indian Evidence Act. These two sections are the foundation of your legal knowledge. These are very important concepts that should be clear to better understand law in the longer run. Be sure to hit the like and subscribe button if you like our video and stay connected with One Polish. So the section talks of may presume, shall presume and conclusive proof. The displayed three terms have their set of differences. To understand this better, you only should know the English linguistic difference between the terms. First of all, we shall talk of may and shall. These two differ only in force of action. That is, one is shall and on the one hand and has a compulsive force that the court needs to strictly adhere to, and may on the other hand is used by applying something widely known as judicial discretion, the freedom to decide what should be done in a particular situation. Second, the conclusive proof. Consider that there is a pair of facts. These facts are such that if one of the facts get proved, the other is dependent on the former fact in such a way that the latter one also gets proved, meaning thereby that if one is proved, the other one also gets conclusively proved. Also, it is important to note here that in the same situation, one shall not be allowed the evidence to be given for the purpose of disproving the same. Don't get confused, as there is definitely much to the same. Rather, jump upon the next point, as you will be clear in the next videos where we shall actually use the concepts. May and shall. A simple Google search shall bring out to you the difference between the two. Also to follow, shall has a compulsive force. On the other hand, may is discretionary. Court uses what is called as the discretion to process the word may, unlike the word shall. Next, in the course of our action is Section 5 of Indian Evidence Act. Evidence may be given of facts and issue and relevant facts. Ask yourself a really simple question, that for what the evidence may be given. Yes, you are right. The evidence shall only be given for the facts and issue and relevant facts. Clearly, these involve 7 points. To know if the facts existed or not at the first place. Secondly, for all the other facts which are relevant thereafter. In short, relevant if that at any point of time touches the facts and issue. It is important in the definition that in this section you shall not be allowed to give evidence of a fact which you are not allowed by the law to give. However, it only pertains to the civil procedure. You may also go back and check out the already discussed topics in the previous video titled as Section 3 Indian Evidence Act relating to fact and issue and the relevant facts. And now, in order to conclude, take a look at the displayed note. Facts and issue and relevant facts shall be explained even further in our course of dealings with the same. Section 5 will be clear once we deal with Section 6 in detail, which we think requires individual attention. So we are going to bring out a proper video for that. Stay tuned. So, all in all, these two sections definitely have their proper place in the code, but these concepts shall become clear when we use them. We don't think that we should give too much emphasis on these two, as these are mostly self-explanatory and direct. Now, thank you so much for watching the video till the end, and as a gesture of thanks, consider the following advice. In order to learn the sections, you must know how to relate them together. On this positive note, let's end the video here.